You pay your HOA dues, you try to take care of your property, but then you get a fine for not pressure washing your driveway or your sidewalk. And that fine leads to more fines and then interest, and all of that accrues.
He has lived in that house for more than 20 years. He bought it out of a divorce. It was all he could afford. He raised his son there. Every dollar of equity he has ever accumulated in his life is inside those walls. And the Homeowners Association tried to take it from him because of algae on a wall, a bucket of water, and a ladder. Not because he stopped paying his mortgage. He had no mortgage. Not because he owed back taxes. Not because a court found him guilty of anything. The man who stood to lose everything he owned after a lifetime of work had committed no crime. He had violated HOA rules. And in the state of Georgia, that is enough. George Watson is 77 years old. He lives on about $20,000 a year from Social Security. When the foreclosure papers arrived, his accumulated debt to the Homeowners Association had grown to more than $9,000. By early 2025, according to court filings, the HOA's attorneys were seeking nearly $15,000 in a summary judgment motion. The man owed that amount, according to those documents, because he had algae on a wall, a borrowed pressure washer sitting outside, and a bucket of water that had not been dumped. So the question is not just what happened to George Watson. The question is how a system gets built where that is even possible. And the answer to that question carries a warning. For anyone watching this who owns a home inside a homeowners association, or has a parent, a grandparent, or anyone they love who does, to understand how a bucket of water becomes a foreclosure notice, you have to go back to Kennesaw, Georgia. The year is 2001. Kennesaw sits in Cobb County in the suburbs northwest of Atlanta. It is the kind of place people move to when they want a quiet community, well-kept streets, a pond nearby, lawn care handled by someone else. The Cedar Lake townhome development went up that year, and George Watson was one of its first residents. He picked the property because it had a backyard for his son. He told reporters he purchased it after a divorce. It was what he could afford. He paid his dues every month, $180. The dues went up $15 every year, but he paid them. For 20 years, he lived in that community, raised his family there, watched it grow. He was not a new resident who had wandered in without understanding the rules. He was there from the beginning. But during the pandemic, something changed. George Watson developed a phobia of mail, according to his own account. He stopped checking it for months at a time. Whether that developed from anxiety, isolation, the general weight of those years, he has not said in detail, and we will not speculate. What the record shows is that he stopped checking his mail, and while he was not checking it, notices from the Cedar Lake Townhomes HOA were piling up. The violations were real. The north-facing side of his townhome had grown green algae. He knew it needed to be pressure washed. He borrowed a pressure washer and a ladder from his neighbor, intending to do the job, and then those items sat on the side of the house for several months while he got around to it. There was also a bucket of water outside that the HOA flagged as a potential mosquito breeding ground. When he finally checked his mail in late 2022, he found a letter. It was not from the HOA board, it was from the HOA's lawyers. The bill was already $6,000. Now, let us pause on that number, because understanding how fines work inside an HOA is the thing that most people do not fully grasp until it is too late. An HOA is not a government. It has no elected accountability to a broader public. It is a private organization that you agree to join when you buy a property in its community. And that agreement gives it the power to fine you, lien your home, and in many states foreclose on it. The fine structure at Cedar Lake, according to court documents reviewed by Atlanta News First, was $50 per day. Every day. For 4 months, from October 2022 through January 2023, that daily fine was running against George Watson's account, producing more than $1,500 in fines per minute onth. On top of that came 7% interest. On top of that came his regular HOA dues of $180 per month. And on top of all of that, layered underneath every number, were legal fees, because the HOA had turned the matter over to its attorneys, Laziga and Johansson, before Watson ever had a chance to respond. By the time Watson saw his first bill, the fee structure had already transformed a maintenance violation into a near unsurvivable financial hole for a man living on $20,000 a year. He tried to explain. He tried to negotiate. According to his account, he spoke with the HOA and tried to work out a resolution. The property management company handling Cedar Lake, Tolley Community Management, whose CEO is Mike Tolley, later told reporters that Watson had been given every possible opportunity to resolve the issue before it reached this point. Tolley also pointed out that Georgia HOA covenants specify that notices are sent by U.S. mail, and that a homeowner choosing not to read their mail is not an association problem. That is the HOA's position. It is worth knowing. Here is also what the record shows. George Watson, according to court documents cited by Atlanta News First, is the only homeowner in the Cedar Lake townhome community that the HOA has taken to court since 2008. In more than 15 years of operating that community, with all of its residents coming and going, Watson is the one person they chose to pursue, to the point of foreclosure. In October 2024, legal fees alone in the case exceeded $3,600. In July 2024, the Cedar Lake HOA formally filed for foreclosure after first placing a lien on his home. In February 2025, the HOA's attorneys filed a motion for summary judgment seeking nearly $15,000. As of September 2025, when Atlanta News first broke this story, George Watson was sitting in his home waiting for a judge to rule on whether he would keep it. He described what the wait had done to him in 3 words: anxiety, sleeplessness, depression. He told reporters, and these are his words directly, "Everything I have is tied up in this house. All the equity I've got to show for my life." Before we go further, if you have a parent, a grandparent, or anyone older in your life who could be exposed to something like this case carries a warning worth keeping. I've put together a free scam-proof retirement guide built around the exact warning signs cases like this keep showing us, how this kind of system works, what to watch for, and the questions to ask before it is too late. You can grab it through the link below or scan the QR code on your screen. It is free, and it is built to be shared with the people who need it most. Now, here is the mechanism that made all of this legally possible. And it is the part of this story that matters most for anyone who owns a home inside an HOA, anywhere in the United States. In Georgia, as of the time George Watson received his foreclosure filing, homeowners associations could place a lien on a home for any amount at all, and then file for foreclosure once the total balance exceeded $2,000. $2,000. The state had no registration requirement for HOAs, no state oversight body, no county or city agency monitoring their conduct, no mandatory process for resolving disputes outside of hiring a lawyer and going to superior court. If your HOA decided to pursue you, your only recourse was to either pay what they demanded or fight them in court at your own expense. George Watson did the second thing. He borrowed money against the equity in his home to pay for legal representation. He took out a home equity loan to fight for a house that the HOA was trying to take from him. As he told reporters directly, "I borrowed all the money that's in the lawsuit." A real estate attorney named Randy Williams, who works with the Williams Law Group of Georgia and who represents both HOAs and homeowners, spoke to Atlanta News First about this case. Williams acknowledged that lien authority exists to make sure HOA dues are taken seriously, and that without consequences, people would simply stop paying. But Williams then said something that cuts to the heart of what happened here. He said about HOA boards pursuing elderly homeowners on fixed incomes, "You want to take their house? You probably could, but do you think that's the human thing to do to a 70 or 80-year-old person?" He added that there are times when a lawyer has to tell a client simply not to do something. He also noted that it would have been cheaper and easier for the HOA to knock on Watson's door or to move the pressure washer and bucket to the back of the house themselves rather than rack up legal fees pursuing foreclosure. Before we continue, please help get this story in front of more people. Like, subscribe, and leave a comment. It genuinely helps these warnings reach the families who need them. And if you know someone elderly, recently retired, or in any position where one trusted person or one private organization handles their finances or their home, share this video with them. One conversation could keep another family from finding out too late. As of September 2025, a summary judgment motion seeking nearly $15,000 was sitting before a Georgia judge. Watson was waiting. The HOA had declined all comment, with the president referring questions to the management company and the attorneys. The attorneys at Lazaga and Johansson did not respond to requests for comment. George Watson, 77 years old, living on $20,000 a year, said the following: "I'm between a rock and a hard place, and there's nothing much I can do about it. What I can do is try and help other people avoid this very sad fate. Now, here is the systemic layer underneath the personal story. The Georgia General Assembly had, for years, tried to reform HOA law in the state. Multiple bills had failed to pass. There was no HOA registration requirement, no complaint process that did not require a lawyer. The $50 daily fine that produced Watson's original debt was legal. 7% interest was legal. Transferring that debt to attorneys before the homeowner could respond was legal. Foreclosing on a 77-year-old man's only asset over a pressure washing dispute was legal under Georgia law. In September 2025, the case sparked new public pressure for reform. A Georgia Senate committee held its first hearing on Senate Bill 361, which proposed raising the foreclosure threshold from $2,000 to $4,000 and preventing fines from counting toward that amount. That bill did not immediately pass, but the pressure kept building, and in May 2026, Governor Brian Kemp signed the Georgia Property Owners Bill of Rights Act, Senate Bill 406, into law. The new law, for the first time in Georgia history, requires HOAs to register with the Secretary of State's office beginning January 1st, 2027. It raises the foreclosure threshold and bars fines, late fees, and attorney fees from being counted toward the amount that triggers foreclosure. It extends the required pre-foreclosure notice period from 30 days to 60 days. It creates a formal complaint and hearing process, so homeowners can dispute HOA actions without going to Superior Court. It requires HOA payments to be applied to dues first before fines or legal fees. It bars HOAs from rejecting partial payments. It is a significant change. But the law contains one sentence that George Watson's story cannot escape. The law is not retroactive. It does not apply to homeowners already in ongoing litigation. George Watson, who the public record suggests helped generate the political pressure that produced this reform, does not benefit from it. His case, as of the date this story was researched, was still unresolved. So, what can you do right now if you or someone you love owns a home inside an HOA? The first thing is to read your HOA's governing documents completely. Specifically, the section on fines, the daily fine rate, the interest rate, and the attorney fee provisions. Know the numbers before any dispute begins. The second is to open every piece of mail from your HOA the day it arrives, even if it looks routine, even if the relationship with the board has been fine for years. Fine escalation in HOA disputes almost always begins with a notice that the homeowner did not open in time. The third is to request a payment plan in writing the moment a balance begins to grow. Many HOA governing documents actually authorize boards to offer payment plans, and a written request creates a paper trail that can matter in litigation. The fourth is to check whether your state has an HOA oversight body or a formal dispute resolution process that does not require hiring an attorney first. Georgia now has one beginning in 2027. Many states do not. Knowing what exists in your state before a dispute starts can change what options you have. The fifth is to contact an HOA attorney. Not your HOA's attorney, your own, at the first sign of a lien or a threat of foreclosure, before the legal fees compound. Waiting to see if it resolves itself is how a $6,000 bill becomes a $15,000 summary judgment motion. George Watson told reporters he hoped that by sharing what happened to him, other people could avoid his fate. He is still, as of this story, waiting for a judge to decide whether he keeps his home. His HOA said it gave him every opportunity to resolve the matter. His HOA also said it was following the law. Both of those things may be true. And the law that made all of it possible was in place for years, governing millions of homeowners across Georgia, while no oversight body existed to question how it was being used. So here is the question this case leaves on the table. If the rules governing the most important asset most people ever own can be enforced by a private organization with no public oversight, no mandatory complaint process, no cap on daily fines, and the legal power to initiate foreclosure for $2,000, how many other George Watsons are out there right now? Watching the number grow, not yet knowing what is coming. Because in the next file, we are going to look at an elderly homeowner did not have a water bucket on their porch. They had a cancer diagnosis during treatment. And the HOA found a way to reach their bank account anyway,